Later this month, the U.S. Supreme Court will hear arguments on what is being billed as the biggest labor case of the century. It's called Janus versus the American Federation of State, County, and Municipal Employees.
I work for Healthcare and Family Services, and I'm forced to pay money to a union that then supports political causes that I don't agree with.
The Janus case threatens to overturn 40 years of precedent. If we lose this case, the entire public sector will be right to work.
The head of the California Teachers Union, which defended a similar case before the Supreme Court back in 2016, calls the Janus case a blatant political attack and warns unions stand to lose millions of dollars and with it their power to negotiate benefits, pensions, and salaries for public workers. UCLA law professor Eugene Wallach is a fierce First Amendment advocate. He filed a friend of the court brief in the Janus case, and he joins us from Los Angeles today. It's so nice to have you with us. This case is so complicated that I really would love for you to explain it to us kind of in pieces. So let's start with where the case begins, with Mark Janus, who was working for the state of Illinois, a non-union member. He had to pay dues. Why did the Supreme Court get involved in this case?
So about 40 years ago, the Supreme Court held that when somebody is being required to pay dues to a union, or what's often the same thing when dues are taken out of his paycheck automatically, then that raises a First Amendment issue because the theory is that's compelled association. And the Supreme Court said, well, that's okay, despite the First Amendment issue. It's okay to withdraw such dues from a paycheck when they're being used to promote collective bargaining purposes, because that's a way of preventing non-union members from free riding on the work of the union. But it's not okay when those dues are taken out for and used for political purposes. So there has to be a mechanism for people who object to the political uses to get a refund or get essentially to prevent their money from being used this way.
So if you go back to that 40 years ago case that you're mentioning, do you believe it was framed incorrectly as a First Amendment issue?
I'm a big believer in free speech protections and of protection from compelled speech as well. But the question is what counts as a speech compulsion? And requiring you to pay money is not something that is generally seen as a speech compulsion, even if the money is used for political purposes. One way we know that is we're compelled to pay our taxes. And those taxes are often deducted from our paychecks. And some fraction of those taxes may be used for speech we disagree with, maybe for public education, which may teach some ideas we disapprove of, or for urging people to recycle, or for a position to for a speech that expresses a position to racism or religious bigotry, or speech that urges people to enlist in the military. Lots of taxpayers may object to that, but we don't view that as a First Amendment problem, that their money is being taken by the government to be used for government speech.
The court has already looked at this case, and in fact, it was decided in that 4-4 because there are only 8 justices on the court at that time. Now that you have the new Supreme Court Justice Neil Gorsuch, there are lots of people who expect, in fact, that they'll rule 5-4 in favor of Mark Janus. What would that then literally mean?
A victory for Janus would indeed be something of a defeat for unions, and some people say that's good. Some people say it would be a victory for taxpayers because they wouldn't have to deal with public employee unions quite as much. So as a practical matter, it'll have all these effects and probably hard to predict effects.
Professor Eugene Wallach with us today. Thank you so much, sir. Appreciate your time.
Always a very great pleasure. Thank you.
Thank you.